The future of state Medicaid funding for Planned Parenthood remains uncertain following an intense oral argument session before the Supreme Court. Justices heard Medina v. Planned Parenthood South Atlantic, a case that could determine whether Medicaid patients have a right to sue when states block access to certain health care providers. The challenge stems from a 2018 executive order by Governor Henry McMaster, directing the state health department to disqualify abortion providers from Medicaid reimbursement. Planned Parenthood South Atlantic and one of its patients, Julie Edwards, argues the federal Medicaid statute guarantees access to, quote, any qualified and willing provider.
I mean, this is a very individual choice that Congress was trying to protect. It's individuals who are hurt. I don't think anyone disputes what this provision does that allows them to choose an individual Medicaid provider to choose from any qualified and willing provider.
South Carolina argues that it retains the power to determine what counts as qualified and that patients can still access other state-approved providers.
It's like when I go to Blue Cross and Blue Shield, and I don't get to pick any doctor that I want. If I want to go to Johns Hopkins, I can't request a doctor unless they're on the list. And this any qualified provider provision works the same way. The state decides who the providers are who are qualified, and you get to choose among them.
Much of the courtroom debate centered on whether patients have any legal standing to challenge the state's decision. A key legal sticking point is whether the Medicaid statute contains the, quote, magic words that signal a congressional intent to create a private right to sue.
I don't even know how to say this line without saying right. Has a right to choose their doctor. That's what this provision is. It's impossible to even say the thing without using the word right.
The debate follows the court's 2023 ruling in Health and Hospital Corporation of Marion County v. Tlefsky, in which justices set a high bar for lawsuits under federal spending laws.
But this court made clear in Tlefsky that this is a high bar. It's atypical. And so if a state is going to be on clear notice, which it has to be to know what contract it's agreeing to, it needs to be really clear.
Planned Parenthood attorney Nicole Saharsky conceded that the bar is high, but argued that the Medicaid provision meets it.
That this provision meets the bar. We don't think that there are a lot of others, if any, in the state plan requirements that would meet that high bar, but this language here, may obtain from any qualified and willing provider, does.
Judges sparred on the meaning of rights and how confusing the interpretation of previous court decisions actually is.
I guess I don't understand what the remaining confusion is, and certainly we're only 2 years out from Tlefsky, so there is no confirmation that lower courts are still confused about what they're supposed to be doing now.
Collectively, this court has failed to give guidance, obviously, that lower courts can follow, that states, providers, and beneficiaries can follow. So one of my goals coming out of this will be to provide that clarity.